Thank you very much. This is David Ruffin, Chair of the North Carolina Historical Commission. Welcome to our meeting. I'd like to welcome all the commission members. We'll call the roll in just a moment, and certainly to the staff and also to the general public joining us by this conference. At this point, I'd like to again welcome us. As you know, I live in Raleigh, but I'm coming to you today from arguably one of the two oldest archaeological rivers in the world, over the New River. I'm about a mile from the Virginia line, overlooking the beautiful New River. And even though I grew up in northeastern North Carolina, it's nice to be on the northwestern corner of the state occasionally for holidays like this. So again, welcome everybody. Certainly would like to begin by calling the roll to determine a quorum, and I will proceed. Dr. Bryan.
Here.
Mr. Dixon.
Present from Wrightsville Beach.
Dr. Denard. Dr. Johnson. Dr. Lowry.
Present.
Mr. Morrison.
Here, and I note that Dr. Johnson's also here.
Okay, good.
Yes, hi.
Hi there, Dr. Johnson. Mr. Reynolds. Ms. Phillips, I know she's here. Ms. Snowden.
Here.
Is here. Dr. Waters. Okay, we have a quorum, and we'll certainly recognize any commissioners joining as they do. And as we always, you have been provided the agenda of the meeting today, and as we always begin to ask for any acknowledgement of a potential conflict of interest on any items that you see on today's agenda. Having heard no indication of a conflict of interest, we will proceed with the approval of two meetings previous minutes. One would be the September 3rd, 2020 meeting of the Historical Commission. And also well, first of all, let's ask for any additions or edits to the September 3rd, 2020 minutes.
Chairman Ruffin.
Yes, Ms. Phillips.
This is Susan Phillips. I would just like to point out that on the September 3rd minutes, at the top of the second page, I'm not a professor. So it says I'm referred to as professor, but I'm just Ms.
Noted, thank you.
Thank you, Commissioner Phillips.
This is
Yeah,
Terry Morrison. With that change, I'll move approval.
Mr. Morrison has a motion. Do I hear a second?
Second.
Yes, Commissioner Bryan has seconded. So all in favor of the approval of the 9/3/2020 minutes, as this is in virtual format, as you know, the rules of that require a roll call vote on every motion. So for the approval of the September 3rd, 2020 minutes, Dr. Bryan.
Aye.
Mr. Dixon.
Yes.
Dr. Denard. Dr. Johnson.
Aye.
Dr. Lowry. Dr. Lowry.
Aye.
Okay. Mr. Morrison.
Yes.
Reynolds. Ms. Phillips.
Yes.
Ms. Snowden.
Yes.
Dr. Waters. David Ruffin, aye. Now we'll move to the September 23rd, 2020 minutes. That, of course, was the hurricane relief subgrants. And I want to express my personal appreciation for Dr. Johnson for serving as acting chair for that meeting. I was unable to attend that. Having been the minutes been submitted to you for review, Do I hear any motion for approval or discussion of any edits or changes?
Terry Morrison moves approval.
Commissioner Morrison has stated his approval motion. Do I hear a second?
Second,
Barb-
Susan Phillips.
Second, Ms. Phillips. So without objection, I'll call the roll. Dr. Bryan,
Yes.
Mr. Dixon,
Yes.
Dr. Denard, Dr. Johnson,
Yes.
Dr. Lowry,
Yes.
Mr. Morrison,
Yes.
Mr. Reynolds.
Is this the roll call?
Oh, yes, good. Good to have you, Noah. Delightful to have you on board. So good, good. Well, we have a quorum, so that's why we were proceeding.
Okay.
Thank you, sir. This is for the approval of the September 23rd minutes. And it has been so moved and seconded, so we're in the middle of the roll call for that.
I'll vote yes on the minutes. I've looked at the things.
Thank you, sir. Ms. Phillips,
Yes.
Ms. Snowden,
Yes.
and Dr. Waters. Okay, so having been approved and with the edit of the September 3rd suggested, they will proceed on to the next item. As you remember, we had on the September 3rd meeting, we spoke, this is kind of in the category of old business, I guess, is rightfully and appropriately, I think Commissioner Morrison recommended that we take in beyond just a statement of appreciation of Millie Barbie, but also ask for a resolution, which again did make reference to her great contributions to North Carolina, all things North Carolina history in a general sense, but certainly to her longstanding and dedicated service to the North Carolina Historical Commission. That has been now presented to you in the form of a resolution. It is on the agenda, and I hope you've had the opportunity to read that. And so I will open that for any discussion at this particular point in time. Do I hear a motion? Again, this was largely for her recognition of her great service, but also very explicitly requesting the governor to grant the North Carolina Historical Commission emeritus status, which is a non-voting status, as you know, but again, is a further recognition of exemplary service, particularly to this commission. And by the way, the letter has already been sent to the governor's office. This is just incorporated within the resolution before the commission at this point.
Chairman Ruffin, I make a motion that we accept the resolution as written. And
Terry
And I
Morrison, second.
second.
I think the Commissioner Morrison got ahead of everybody else. He appears to be leaning forward, and that's probably for more reasons than one. So with Commissioner Snowden moving and seconding by Commissioner Morrison that we adopt the resolution on Millie Barbie, I open that for a vote or ask for a roll call vote. Dr. Bryan,
yes.
Mr. Dixon,
Yes.
Dr. Denard, Dr. Johnson.
Resounding yes.
Good to see you. This is the first time I've seen you. Dr. Lowry,
Yes.
Mr. Morrison,
Yes.
Mr. Reynolds,
Yes.
Ms. Phillips,
Yes.
Ms. Snowden,
Yes.
Dr. Waters. Okay, so we move with that, and that leads us to the accessions and deaccessions, which we, as you know, traditionally have at near year end, among other things, for potentially for tax issues that people that are donating these items to various historical venues in our state. So with that, I will ask Dr. Kevin Cherry, if he would be so kind as to walk us through the sessions, and then we have, I think, a few deaccessions.
All right, we will probably have 3 separate votes. We will put all of the accessions in one vote. Then we will put the deaccessions in another vote. And then those are for historic sites and museums. And because a separate law governs accessions and deaccessions of archival materials, we will then move to deaccessioning items from the archives, but those will be back into custody of the governor's office, so they're not being gotten rid of. But I will let our state archivist explain that when the time comes. So first, you've received ahead of time the accessions list for the Museum of History, the Mountain Gateway Museum, the Maritime Museum, and our historic sites. If anyone has any questions about any of the individual items, please ask me when I finish. I'm going to give a quick overview of not all of the items, but just some of the items that we will be accessioning into our different historical institutions. But if you have any questions about any of them, please ask. So at the Museum of History, we have a fairly large collection of donations from Betty Debnam Hunt, of her husband's artifacts related to his military career. As probably a number of you know, Ms. Hunt was the creator of the mini pages that went nationally in newspapers around the country, and she has just passed away after making this donation to the Museum of History. We also have, as a part of our collecting around COVID and the pandemic, we've received masks made by Miss Mary Blum, who has been making those masks for all types of volunteer organizations and in the state. And she also made me one, and I'm very happy for that. We have a gift of Rear Admiral Edwin Anderson materials. He was the Medal of Honor winner in the Navy from the Spanish-American War, and that came from Peggy Stallworth. And we also have a number of items related to the Black Lives Matter protests and the George Floyd protests around the state, from Greensboro and Raleigh. And those are true works of art. And I believe that those will be exhibited any number of times in the future. And we're very thankful to the artists and the community organizations that have donated those to the Museum of History. At the Mountain Gateway Museum, we have a couple of campaign signs that will be added to the collection there, from Josh Dobson's campaign and from Madison Cawthorn's campaign. At the Maritime Museum, we have a poster that shows the COVID impact on the pirate invasion in Beaufort, a nice early 20th century compass that was used on a fishing vessel there at the Outer Banks, and a late 17th century musketoon, which was purchased with friends' money to be added to the Blackbeard exhibit at the Maritime Museum, because it is very close to the remnants of such a gun that was found on the Queen Anne Revenge site. So it'll be an interpretive material. And then from historic sites, we have a number of items that were purchased, 18th century related items to hunting, that will be added to the new exhibit that we're creating for the new exhibit hall at there at Bath. So that's an overview of the artifacts being added to our historical institutions. If anyone has a question about any artifact that I maybe didn't mention, please ask now. All right, not seeing any questions. Mr. Chairman, we can proceed to a vote for accessioning these items.
These items to be accessioned by the North Carolina Museum of History, the North Carolina Mountain Gateway Museum, the North Carolina Maritime Museums, and the North Carolina State Historic Sites. At this point, I will call the roll. Well, do I hear a motion to that effect first? Excuse me.
I move their approval.
Commissioner Bryan, do I hear a second?
Harry
A
Morrison,
second.
second. Let Dr. Johnson have it.
Okay. Dr. Johnson has seconded Dr. Bryan's motion to accept the recommended accessions, and we'll proceed with the roll call. Dr. Bryan,
Yes.
Mr. Dixon,
Yes.
Dr. Denard, Dr. Johnson,
Yes.
Dr. Lowry,
Yes.
Mr. Morrison,
Yes.
Mr. Reynolds,
Yes.
Ms. Phillips,
Yes.
Ms. Snowden,
Yes.
Dr. Waters, and David Ruffin, aye. I may have failed to vote on these other items, and I apologize, but I certainly agreed with the motions in each case. Okay, Dr. Cherry, do you want to proceed on the second leg of this, I guess, to talk about the deaccessions?
Right. So we have, always with deaccessions, we have two votes. One on whether we want to deaccession the item, and the other is the vote on the means of deaccessioning. If you've attended several of the commission meetings recently, you can't help but notice that the Maritime Museum is going through its warehouse and reevaluating its collection. And that's why we have a lot of well, not a lot, but we have most of our deaccessions have been related to items at the Maritime Museum. And I don't know exactly where they are, but I suspect that they may be getting toward the end of that reevaluation. So from the Maritime Museum, we only have deaccessions from the Maritime Museum. These are 6 outboard motors, and they are all to be deaccessioned through public auction, and one 1950s flat bottom skiff, which will also be deaccessioned by auction, public auction. And so those are the deaccessions, and that is the means by deaccessioning, public auction. Mr. Chairman.
Yes. Do I hear a motion to accept the staff's recommendations for deaccessions to the North Carolina Maritime Museums?
This is Susan Phillips. So move.
Thank you, Commissioner Phillips. Do I hear a second?
Harry Morrison, seconds.
Thank you, Commissioner Morrison. Let's proceed to a roll call. Dr. Bryan,
Yes.
Dixon,
Yes.
Dr. Denard, Dr. Johnson,
Yes.
Dr. Lowry,
Yes.
Mr. Morrison,
Yes.
Mr. Reynolds,
Yes.
Ms. Phillips,
Yes.
Ms. Snowden,
Yes.
Dr. Waters, David Ruffin, yes. Okay, Dr. Cherry, I believe you indicated we need a bit of a third tier of voting relative to archival items.
We need to also vote on means of deaccessioning. We voted to deaccession. Now we have to approve the method chosen by the institution.
Well, can I ask a question? We voted to accept staff recommendations, and those are included in the materials. And so does that not take care of it, or do we have to have a separate vote?
Well, since they're all by auction, we can do that. Sometimes when it's mixed, it's a little confusing. That's why we ask for a separate vote. But if it is all right, Mr. Chairman, we can just say that the motion included both deaccessioning and method.
Since there was no differentiation, without any objection from the rest of the commission, I certainly think that's practical.
And now we move to the archives deaccessions. Archival deaccessioning is governed by a different law. And so what we're doing here today is, most accessioning into archives is handled by law, not by the commission and through a policy. So that leaves us deaccessioning that the Historical Commission deals with. And our state archivist, Sarah Kuntz, will explain exactly why we are deaccessioning these items and what we mean by deaccessioning in this case.
Thank you, Dr. Cherry. Sarah Kuntz, Director of the Division of Archives and Records. And I'll just briefly tell you a little bit of background, and these records are all related. So I'm going to treat them as one group, but there's 4 separate scheduled items in this deaccession proposal. So when we have a deaccessioning proposal from the archives, the first step is to take it to Dr. Cherry with a recommendation on what's going to happen to those records. And unlike artifacts, there's quite a variety of final dispositions that can be considered with archival records. And in this case, what we're asking to do is deaccession is only a change in legal custody of the records. So they're going to physically stay in our facilities, but we would be deaccessioning these records back to the legal control of the governor's office. And as by way of background, traditionally when a governor leaves office, we take over all archival records coming out of that office. And that has included all of the materials in the past that have been related to the governor's power to pardon and to grant clemency. And for those of you that have been on the commission for a couple of years, about a year ago, we started reviewing those records that are related to pardon and clemency and systematically transferring legal custody back to the governor's office. This is the one place where we're not going to accession the archival records immediately. And that's because we have found over the years that the governor's office needs to retain legal custody of these files. They're calling them back quite a bit. They're adding to them. They're doing things with them. So they're really an active series. And they're really the one thing that spans from administration to administration. So they need to stay in the legal control of the governor's office. And then we have subsequently changed the records retention schedule that after 75 years, which we feel is a good long period where they would no longer be active and they no longer need to be in those files, then they will become archival records again, fully in the control of the department. But as of now, and really the governor's office does control access to those right now. We don't do any reference to them without checking with the governor's office. They're highly controlled materials anyway. So we felt like this was an appropriate change to reflect what we're doing with our retention schedules now. So these are all some materials that were related to our initial efforts, including some information about pardons, some miscellaneous inmate correspondence, both from regular sentencing and from death row cases, as well as some additional commutation files. And I'm happy to answer any questions, but again, these would all we're proposing, and Kevin has agreed with our proposal that they would remain on the shelf in our physical space, but the governor's office would retain all legal control of these materials.
All right, Mr. Chairman. So the department asked the Historical Commission for the ability to deaccession these items, physically house the items, but the governor's office retain legal control of the items, which basically means that when people come into the archives and want to see them, they are active records in the governor's office, and it would take permission from the governor's office to see and work with the files.
Thank you, Dr. Cherry and Ms. Kuntz very much for the clarification. So the request from staff is before us, pertinent to particularly the files relative to governors. And therefore, is there any discussion by the commission relative to this request by staff? Do I hear a motion to accept?
This is Perry Morrison. I'll make a motion to deaccession these items to the control of the governor's office.
Barbara
Thank-
Snowden, I'll second that motion.
Moved by Commissioner Morrison, seconded by Commissioner Snowden. To that effect, I will call the roll. Dr. Bryan,
Yes.
Mr. Dixon,
Yes.
Dr. Denard, Dr. Johnson,
yes,
Dr. Lowry,
Yes.
Mr. Morrison,
Yes.
Mr. Reynolds. Mr. Reynolds, are you still on?
Yes, yes,
okay.
I'm sorry.
Thank you. No problem. Ms. Snowden
Yes.
and Dr. Waters. Okay, and David Ruffin, yes. So approved. Any other items relative to that, Dr. Cherry? The sessions or deaccessions?
We have finished with our accessions and deaccessions.
Thank you, sir. Okay, the final item on the agenda today is, I believe, relative to a matter of the Confederate monument in Pasquotank County. There was a request from the, I believe it's the North Carolina Division Sons of Confederate Veterans, through the auspices of a Mr. H. Edward Phillips, that requested the North Carolina Department of Natural and Cultural Resources for a declaratory ruling relative to this matter. Secretary Harrington, in responding to that, indicated that they were not wanting to, or actually denied a request for a declaratory ruling, and indicated it should be and would be sent to the North Carolina Historical Commission. There was commentary within the letter back to Mr. Phillips, as you indicated, that the secretary indicated probably if it were within the department's appropriateness to respond, they probably would not be in the affirmative, largely citing precedent relative to the statute from the city of Reidsville that had been looked at and adjudicated a few years back, I believe 2011. At this particular point, I would like to ask Karen Blum, who is Deputy Attorney General and in this matter serves as legal counsel to the Historical Commission, appropriate because, as you know, this was done in the matter of a filing or a petition that has been filed, and therefore it does probably require legal advice. At the risk of prejudicing the committee, I will say that I prefer that we hear Deputy Attorney General Blum's statements in open session, but we certainly have the privilege as a commission to go into executive session to hear Deputy Attorney General Blum's comments. I would therefore like to just get the sense from the commission members as to their first feeling the necessity or not of going into executive session or closed session in that regard. Remember, under a closed session, we would only hear the comments by the counsel. It's not a deliberative process whatsoever. It's just a matter of conveyance of a legal opinion. Do I hear any discussion relative to
I
that?
think this is Sam Dixon. I think we ought to do it in the open. I think this is a matter that the public is interested in, and I think that whatever advice we get from legal counsel, really at this point ought to be open.
Thank you, Commissioner Dixon. Are there others that feel, I guess, and perhaps other comments that you would make, but Short of that, I hope it's appropriate to use the chair's discretion to ask Deputy Attorney General Blum to do that. But again, for anyone that feels strongly about it, you certainly have the right to ask for a closed session. And therefore, we're in a position, for what I'm understanding, then, that we don't ask for a waiver of that attorney-client privilege, so to speak, by going into public session. So having heard no objection to proceeding in the public realm, then I would ask Deputy Attorney General Karen Blum, if she would, to speak to us relative to this matter, relative to the Pasquotank Confederate Monument.
Thank you, Mr. Chairman. I think before you proceed, I'm not quite sure, but I think the last time you took a vote on that to go into closed session, or to waive privilege or go into closed session.
No. Okay, that's appropriate advice. So what I would like then ask for, since there's apparent consensus, is do we have a motion to waive a closed session relative to attorney-client privilege in this matter?
I'll make that motion. Sam Dixon.
I'll
Thank you,
second
Commissioner
it.
Dixon. Thank you, Dr. Bryan has seconded. All in favor of that will say aye by roll call. Dr. Bryan.
Yes.
Mr. Dixon.
Yes.
Dr. Denard. Dr. Johnson.
Aye.
Dr. Lowry.
Yes.
Mr. Morrison.
Yes.
Mr. Reynolds.
Yes.
Ms. Phillips.
Yes.
Ms. Snowden.
Yes.
Dr. Waters and David Ruffin, yes. Okay, proceed, Deputy Attorney General Blum. Thank you.
Thank you, Mr. Chairman, members of the commission. My name is Karen Blum. I'm a Special Deputy Attorney General in the North Carolina Department of Justice. And I represent the commission just on matters referring to or related to the relocation or removal of monuments. I understand that the commission has waived its attorney-client privilege and wishes to request and receive legal advice in open session, and I will do that. I would just like to note that my opinions are my opinions in the capacity of your attorney, and not necessarily the opinions of the Attorney General's office. So that having been said, I'd like to go through a few things. The petition that was submitted by DNCR, the basics of that petition, the statutes related to monuments, and who can petition the commission, and then what the commission can actually do about that. That'll take 12 to 15 minutes, and I'd like to ask your patience as I methodically work through this and hold your questions until after I finish, and then I'll be happy to entertain any questions if that's all right. As Chairman Ruffin said, the Secretary of the Department of Natural and Cultural Resources received a petition on September 22nd for declaratory ruling regarding the applicability of a statute, and that was GS 100-2.1 to the Pasquotank Confederate Soldiers Monument. And this was captioned, quote, before the North Carolina Department of Cultural Resources. On October 21st, the secretary denied the petition because it was addressed to DNCR and also because it requested relief from the Historical Commission, but was addressed to DNCR. She also stated that the Historical Commission is an independent advisory and regulatory body with independent rulemaking authority, and that the matter was not appropriately addressed to the department. So she denied that petition and forwarded the matter to the commission. So now the question is, what does the commission do with this? The petition for declaratory ruling has already been denied by DNCR, so in my opinion, it's dead. But the Historical Commission could look at this petition, and I'm using a little p, not a capital P for a legal filing or anything. It can look at this as it did the citizens' petitions for the removal of Silent Sam on UNC. This Commission received, I can't remember how many, it must have been 6 or 7 petitions from citizens. And it put those on the agenda, and the commission can do the same thing here. So how do we go about doing that? I'm going to go through the basics of what was received by the department. Who exactly is requesting relief? In this case, it's the Colonel William F. Martin Camp 1521 Sons of Confederate Veterans and the North Carolina Division Sons of Confederate Veterans. And the William F. Martin Camp claims to be the legal successor in interest to the United Confederate Veterans and claims a reversionary interest in the monument. So there's no allegation that this is state-owned. So what monument are we talking about? This is in Pasquotank County. It's the Confederate Soldiers Monument near the county courthouse in Elizabeth. And on July 13th of 2020, the Pasquotank County Commissioners voted to remove that monument from the property there. What exactly does the SCV want? And since both groups, one is the local group and the other is the state group, I'm just going to talk about them in terms of the SCV groups. What do they want? They want the Historical Commission to schedule an oral hearing with a briefing schedule. And they also want the Historical Commission to acknowledge that Pasquotank County is a political subdivision of the state and subject to the provisions of the Cultural History, Artifact Management, and Patriotism Act of 2015. The SCV also seek a declaratory ruling that the state or any political subdivision of the state must seek approval of the Historical Commission prior to relocation or removal of a monument from public property. So the next step that we need to take is we need to look at this act. We need to look at the statutes. What are the basics of Chapter 100, the Cultural History, Artifact Management, and Patriotism Act of 2015, which I promise is the last time I'm going to call it that. I'll call it the Act or refer to it by statutes or Chapter 100. GS 100-2 says that a monument may not become the property of the state or be placed on state property unless it's approved by the Historical Commission. Another statute under that chapter, 2.1a, 100-2.1a says a monument owned by the state may not be removed, relocated, or altered without approval of the Historical Commission. So here we have statutes that talk about things being put on to state property or gifted to the state, if you will. And then we have a statute that deals with taking monuments off, monuments owned by the state, removing them from property without Historical Commission permission. 100-2.1b has limitations, though, on the removal of things called objects of remembrance on public property. Okay? Not state property, public property. An object of remembrance is defined in the statute. It includes monuments or a display of permanent character commemorating an event, person, or military service in North Carolina history. So the statute says an object of remembrance on public property may not be permanently removed. It may only be relocated, whether temporarily or permanently. There are some exceptions, though, and these exceptions are taken outside of 100-2.1 in its entirety. And those exceptions are for highway markers, objects of remembrance owned by private parties on public property where there's a legal agreement, or an object of remembrance for which a building inspector or similar official determined poses a threat to public safety. All right, legal gobbledygook, what does all of this mean? We need to look at some more legal stuff. The first thing and the biggest thing is who can petition the Historical Commission? You have to be a person aggrieved. The requirement under the Administrative Procedure Act is that you must be a person aggrieved by an administrative action. And that's similar to standing. If you're a lawyer, you know about standing. A person aggrieved is defined as a person or group of persons of common interest, directly or indirectly affected substantially in his or her or its person, property, or employment by an administrative decision. The other thing we have going on here is this request for a declaratory ruling. And the Administrative Procedure Act says, on request of a person aggrieved, an agency shall issue a declaratory ruling as to the applicability to a given state of facts of a statute administered by the agency. All right. Your head's probably floating around. You know, all this stuff is probably floating around in there. How do we sort all this out? Well, there's precedent. And as Chairman Ruffin stated, in 2013, the Court of Appeals, the North Carolina Court of Appeals, ruled on the matter of Historical Preservation Action Committee and North Carolina Division Sons of Confederate Veterans versus the City of Reidsville, North Carolina Department of Cultural Resources, North Carolina Department of Transportation, and United Daughters of the Confederacy, North Carolina Division. And if you're not familiar with that, very quickly, that case involved a Confederate monument that was located in the middle of a road in Reidsville. It was originally erected by the UDC. It was struck by a van and partially toppled. And the toppled soldier and the remaining plinth, obelisk, base, whatever else was there, was removed by the city of Reidsville. Well, the petitioner's Historical Preservation Action Committee and the SCV petitioned DCR for a declaratory ruling for improper removal of that monument. Now, HPAC claimed it suffered an economic, taxpayer, and aesthetic injury. The SCV claimed to be a legal successor in interest to the United Confederate Veterans, and they claimed reversionary interest. Well, what happened? The petitioners were found to lack standing, and DNCR just said, look, there's no injury here that we can fix by a favorable rule. There were appeals, and eventually the Court of Appeals said, look, there's no economic standing here. There's no proof of any kind of lowered land value or decreased business activity. More importantly, though, it said there is no standing to challenge the disposition of public property here because the removal was not the result of DCR or DOT. The Court of Appeals also said that there's no standing to challenge aesthetic injury, not even to an environmental plaintiff, much less a plaintiff seeking judicial review of an agency decision. So let's apply this precedent to this case. There are some similarities here. The SCV in this case claims taxpayer standing and aesthetic injury. However, nothing in the document before the commission says that the SCV, either one of them, is aggrieved by an action of a state agency. Specifically, the document says they are aggrieved by the vote of Pasquotank County Board of Commissioners. And according to a link in that document, it's a link to Doc South, which is UNC's website on monuments. The inscription on the monument says it was erected by the DH Hill chapter of the UDC. So in my opinion, as the attorney to the Historical Commission, neither of the SCV groups have standing to bring the matter before the Historical Commission. Now, even if the SCV had standing, what could the Historical Commission do? Nothing. The SCV contends that the state or any political subdivision of the state must seek approval of the Historical Commission prior to removal or relocation of the monument from public property. That's not what the statute says. Remember, the statutes say that monuments cannot become or be placed on state property without Historical Commission permission, and monuments owned by the state can't be removed or relocated without Historical Commission permission. There's no allegation in the petition that the monument is state-owned. There's not even an allegation in the petition or in that document, petition little p again, alleging that there's some sort of state undertaking. The statute requiring approval of the Historical Commission to remove monuments refers to state-owned monuments. The SCV groups contend that counties are political subdivisions of the state, therefore the statute must apply to them too. Well, in my opinion, the general statutes allow counties to own their own property. That's in chapter 153A. The general statutes also allow county boards of commissioners to execute the rights and duties of the counties. So in my opinion, as counsel to the Historical Commission, the commission doesn't need to approve the removal of the Pasquotank Confederate Soldiers Monument in this case. Are there any questions?
No, I thought that was a thorough overview of where we stand and what our responsibility would be at this point. Thank you.
Karen, I wanted to ask you just a few things, just to make sure that I'm understanding your analysis. The SCV does not have standing to bring this. That's one thing you're saying, right? The second thing is it was never erected on state property and it's not state owned, so we don't have any authority over it. And the third thing is it's county property and the county has the right to either erect it or take it down.
Thank you, Commissioner Morrison. Yes, as to 1 and 2, I think there is no standing. And even if they had standing, I don't think this would properly be before the commission because the commission can't fix what the petitioners are asking for, what SCV is asking for, whether that's a redressability issue or whether that's a jurisdictional issue. I'm not really sure. And I'm just pointing out, I'm not giving advice to the counties, but in looking at the statutes, because the SCV is asking the Historical Commission to issue a declaratory ruling or ask DCR to issue a declaratory ruling that Chapter 100 applies to political subdivisions of the state as well in terms of going before the Historical Commission. I'm just saying I disagree with that. I think that the statutes talk about it has to go before the Historical Commission if you want to give a monument to the state, or if you want to put a monument on state property, or if you want to take a state-owned monument away. And I note that there are specific statutes for counties and county boards of commissioners to own property and to control their own affairs. So I don't think it's properly before the commission.
And if just for the benefit of the non-lawyers on the commission who may not understand the concept of standing, what it means is if someone doesn't have standing, they don't have the right to ask for relief. Correct? Ms. Bloom?
That's correct. And probably more specifically here, they have to be a person aggrieved. And there's a case out there that says that for persons aggrieved and standing, it's almost the same thing.
And I wanted to ask you just one more thing about your analysis of the statute. There is a phrase in there about objects of remembrance and not being county owned, but on public property. Does that change your analysis in any way?
It does not, Commissioner Morrison. And the reason is there is a subsection A, which talks about the Historical Commission. Subsection B says nothing about the Historical Commission.
Okay.
It just talks about public property, and subsection A is subject to any limitations in subsection B to begin with. And so I think what we're left with is if it's a state monument, state-owned monument being removed, then it would have to go through the Historical Commission. But there is nothing in B that says that all public property, regardless, all objects of remembrance on public property, regardless of ownership, have to go through the Historical Commission. It does not seem to make sense that that county affairs would run through the Historical Commission when they have the right to own their own property, and they have boards of commissioners who determine the rights and duties of counties. So I construe those statutes, the subsections together, to mean that if it's a state-owned object of remembrance, it goes through the Historical Commission. And if it's not, it goes through the county commissioners, or I guess it could be a municipality that owns it, a city-owned object of remembrance.
And I hate to be dominating the questions, but if, let's assume that we decide not to take this up, that they don't have standing, and that's the reason that we are denying the request. Would it be beneficial to us as a historical commission to not only state that, but also state our attorney's analysis of the request, not just the standing issue, but all the issues? Because if it goes up on appeal, and then the North Carolina, the Court of Appeals determines that we were wrong about standing and that we need, it's going to come right back. But if we go ahead and state something to the effect of, our position is that county-owned property is the dominion of the counties of North Carolina, not the dominion of the North Carolina Historical Commission, it seems to be that might also send a message to anybody else out there who's going to keep sending us these requests.
Commissioner Morrison, I would just note that it's certainly within the purview of the commission to issue whatever statement it wants to. It could just also decline to hear the matter, which it did, I believe, with the petitioners from UNC. I don't think there was anything written that was issued. It was just, yeah, we don't really think we can hear this, take a vote on it. The other thing I would note is that it might be, without looking into the matter further, it might be more accurate to say that the Historical Commission really doesn't have any say over this matter. Instead of outright saying, we believe this is a county matter, I'm not advising the counties, I can only advise the Historical Commission. What I'm saying, I think, is I don't think it's properly before the commission, because counties can do what counties do. And this matter does not appear that there was anything stated within the petition, little p petition, that would bring it under the Historical Commission's review.
Would it be incorrect to say we don't have standing and we don't have jurisdiction, and just leave it at that?
I don't think it's incorrect, again, whether it's a jurisdictional issue or a redressability issue. I don't know. But I think you could say that it's probably fair to say that there's no jurisdiction. If you look at just at chapter 100, there's nothing in chapter 100, I don't think, that says in subsection B that everything runs through the Historical Commission, whether it's municipality owned or county owned.
Interesting.
Thank you, Ms. Blum.
Yes.
Other comments or observations?
I just want to thank you, Perry, for making those observations, because if I understand what you're saying, we're trying to, in some ways, preempt folks continuing to come back with almost the same exact language over and over again. But that if we state what our position is clearly enough, maybe it will help maybe truncate some of those petitions coming for little p petitions coming forward. So that's how I'm understanding what the question, this discussion right now.
Commissioner Johnson, I agree with you, but remember that the records, the minutes of our deliberations are also recorded, right, publicly, and reflect the spirit of whatever we may determine our ultimate position is. But being one of the non-lawyers, I will concur with the sense that one of the first lessons I learned, well, first of all, let me preface that by saying any objective person would certainly understand the incredible amount of time, effort, and dedication has been done by this commission and other members of previous to this board in the last 3 years relative to related matters of this nature. So it's not that we in any way dismiss as non-substantive requests such as this. But one of the things that I certainly learned as member and chair early on was that there are legal and has to be legal gateways established, particularly in this environment when many of these monuments and items of remembrance by their nature are very controversial. And therefore, this commission would be inundated by what I remember to be in my non-legal mind, the civilian walking down the street who's offended by this particular plaque or this particular monument, then standing in line in front of the Historical Commission to petition its removal. Therefore, the importance of the standing, i.e. the non-lawyer's interpretation of that, the gateway, if you will, to our body, our commission, would have to have some degree of qualification. And I think that is already in place. Doesn't need to be, in my opinion, reestablished by whatever our ruling is, but I just certainly would like to add that I do believe our comments that we're making as of right now could indeed reflect the spirit where we are.
Yeah, Mr. Chair, could I make a question of council?
Yes, Commissioner Reynolds.
Ms. Bloom, I just had a clarification question for you. In your analysis, and I don't want to go back through the whole 15 minutes, but you used the word property, and I wanted to make sure that that was clear in the context of state and non-state. So you mentioned the object itself, the statue is property, but property can also be the land or the place with which it sits. And I just wanted to make sure that was clear, especially in the context of relating that to a county, because you say county property, and I wanted to make sure that the physical location, the land on which an object might sit, is distinguished from the object itself, which is property or who owns that particular object. If you could clarify that for us, that got a little confusing for me as a layman when you were discussing that, and that's all I had was a point of clarification. Thank you.
Thank you, Mr. Reynolds. I think that the statute refers only to either public property or for GS 100 related to the Historical Commission, it talks about property of the state, or it may not become state property. And I think these are talking about monuments. In 100-2.1b, the limitations for removal talk about objects of remembrance on public property. So I think it's a little bit unclear, but I construe this to mean the monuments, if a monument is on public property, situated on top of public property. And regarding review by the Historical Commission, it talks about monuments owned by the state or becoming the property of the state or being placed on property owned by the state. So the first part doesn't really match the second part in terms of the way it's worded, I don't think. I don't know if that really even answered your question, but it's not entirely clear, except that in the section on limitations on removal, it says an object of remembrance located on public property.
No, that's fine. I think you clarified the language. I understood your analysis. Thank you.
Other comments or observations?
I have a question, Mr. Chair. What, and I guess for the attorney also, what is it that you all are looking for from us today?
It is, Commissioner Morrison, it's simply put, again, non-legal, and I would expect someone like yourself to perhaps catch it more appropriately from a legal standpoint, but it's my sense that we have one of two options. We either hear this matter further or we don't. Again, Ms. Blum, if you disagree, please so cite.
Mr. Chairman, I believe when this came up with the petitioners, the citizen petitioners who wanted the removal of Silent Sam, I believe the commission just merely declined to hear the matter. So there is a matter of consistency here, whether or not the commission could actually do something else, like issue something in writing. I suppose it could, but then you have to determine, is that really acknowledging that the petitioners, little p, have standing? So I think you could decline to hear it, which is what you did the last time with UNC, or, I had not really contemplated, hadn't really thought about anything else in writing.
Ms. Blum, would this decision be conveyed to the group by, not this group, but the group making the petition, by letter prepared by you and signed by the chair of the commission?
Commissioner Morrison, I think the last time it was just that the commission declined to hear the matter, and I don't know that there was anything sent out to the citizen petitioners. I suppose you could send a letter saying that the commission declined to hear the matter.
Well, if they're unsuccessful, then they should have somewhere to appeal. And if we just decline to hear it, then where would their appeal lie?
Well, I don't want to give them legal advice, but I'll point out again that in my opinion, the petition it's already been declined or denied by the Department of Natural and Cultural Resources, which is the agency to which it was addressed.
Right, so they'd handle it through that appeal process.
Right, so it was really just forwarded. My take on that is the matter was forwarded by the secretary to the Historical Commission to do with what it deemed appropriate. I'll point out that the SCV previously communicated directly with the Historical Commission by sending correspondences to the chair directly. In this matter, they didn't, and the petition that went to DNCR was captioned to DNCR, and it was sent only to the secretary. So I think the matter is really dead. And so the question now is, what does the commission want to do? Entertain the matter or just decline to entertain the matter?
Mr. Chair, I'm no lawyer, but I do know that the case of the citizens petitioning from Chapel Hill was slightly different in the fact that they were before the body face to face when we declined to hear. And also the fact that in the Reedsville case, when that was, the citizen petitioners were found not to have standing, they did receive a letter from the secretary of the commission to them informing them of the decision of the commission.
Oh, thank you, Dr. Cherry. Certainly, as I said to Commissioner Johnson a moment ago, the public record will be the public record, whatever our decision is. But I think as a matter of courtesy, that would certainly not be inappropriate to just send a letter of our decision.
I agree with that.
Okay, any other comments or observations relative to, yes, an excellent presentation by Deputy Attorney General Karen Blum. Thank you. So obviously I'm aware of the amount of diligence and time she has spent on this matter, and I both personally and want for the commission to collectively thank her for that.
Absolutely.
Thank you.
And Mr. Chairman, at this time, I think that it'd be appropriate to hear a motion for the feeling of the full commission.
Yes, I was certainly about to go in that direction. So I'm entertaining of a motion of our position from any member.
This is
I
Susan.
move. Oh, go ahead, Susan.
Commissioner Phillips, yes.
I move that the Historical Commission decline to address the petition because it's not properly before, the matter is not properly before the Historical Commission.
Thank you, Commissioner Phillips.
I second that motion.
Motion that basically says that we decline to take any action on the petition because of this matter, because it's not properly before the commission. It's been made by Commissioner Phillips, seconded by Commissioner Johnson. Do I hear any discussion? Having heard none, I will proceed to the roll call. Dr. Bryan.
Yes.
Mr. Dixon. Mr. Dixon.
He had to leave.
Okay, Dr. Denard is not here. Dr. Johnson.
Yes.
Dr. Lowry.
Yes.
Mr. Morrison.
Yes.
Mr. Reynolds.
Yes.
Ms. Phillips.
Yes.
Ms. Snowden.
Yes.
Dr. Waters is absent, and David Ruffin, yes. So the motion is carried unanimously relative to this matter of the Pasquotank Confederate Monument. No other matters are on the published agenda, so at this point, I will certainly entertain a motion for adjournment, but also prior to that would certainly wish each and every one of you and this commission, the staff, and certainly the general public a very happy Thanksgiving and a healthy and safe one, particularly given where we are these days. Do I hear a motion for adjournment?
Barry Morrison moves.
Thank you, Commissioner Morrison.
Second.
Thank you, Commissioner Johnson. All in favor? Here we go. One more time for a roll call. Just enjoy hearing your name, reading your names. Dr. Bryan.
Yes.
Mr. Dixon, if he still is with us. Dr. Denard. Johnson.
Yes.
Dr. Lowry.
Yes.
Mr. Morrison.
Yes.
Mr. Reynolds.
Yes.
Ms. Phillips.
Yes.
Ms. Snowden.
Yes.
Dr. Waters not with us, and David Ruffin, yes. Again, carried unanimously to adjourn. Again, thank you so much, and be safe.
Have a happy Thanksgiving.
Happy Thanksgiving.
Happy Thanksgiving, all.